Ever wonder why those letters feel so airtight, even when they're not? Today, I'll explain non-compete agreements like you're 5 years old. By the end, you'll know exactly whether yours can actually hurt you and what to do about it. You spent 2 years at a job slowly grinding you down. Bad management, flat pay, zero growth. You finally land something better. Better title, better money, better everything. You give notice, walk out the door, and 2 weeks later, you're at your new desk, finally breathing again. Then the thick envelope shows up, with a firm name you don't recognize in the corner. Inside, it says your old employer believes you are in material breach of your non-compete agreement. It demands you cease employment immediately and ends with the word litigation. Your first instinct says the law is already against you. That instinct is exactly what the letter was designed to create. Here's what a non-compete actually is, and why it matters. When you got hired, maybe day one or buried in onboarding paperwork, you signed something saying you wouldn't work for a competitor after leaving. It covered a certain amount of time, a certain area, and a certain kind of work. Here's the first thing that cracks the whole foundation. Courts don't automatically enforce these agreements. In fact, studies suggest that somewhere between 30 and 40% of American workers have signed a non-compete at some point. Many without fully understanding what they agreed to or whether it would even hold up. Think of a non-compete like a leash your employer uses to keep you from the competition. But the law asks, how long is that leash? And how wide is the yard? If the leash is too long or the yard is too big, the whole thing gets thrown out. Courts in most states require non-competes to be reasonable in duration, geography, and scope of work. Most aren't reasonable at all. A 2-year ban combined with a nationwide territory and a restriction so broad it covers your entire industry. Judges look at those terms and say, no. They call it overbroad. Legal language for, you went too far, so you get nothing. And here's something that surprises almost everyone. In many states, courts don't trim the agreement to fix it. They throw the whole thing out. The clause doesn't get edited. It dies completely. It's also worth understanding why courts take this position so seriously. Non-compete agreements restrict a person's ability to earn a living, and judges treat that as something requiring genuine justification, not just boilerplate language from a template. When an employer can't demonstrate a real, legitimate business interest that matches the scope of what they're restricting, the court sees the agreement for what it often is. A control mechanism, not a protection mechanism. Some legal scholars argue that overly broad non-competes suppress wages across entire industries because workers can't move freely to employers willing to pay them more. That's part of why courts have become increasingly skeptical and why the trend is moving steadily toward narrower enforcement, not broader. The state you work in matters enormously. California bans non-competes almost completely. It doesn't matter what you signed. California courts simply will not enforce them, with very narrow exceptions. That's not a loophole, that's the law. It's also why so many tech workers in Silicon Valley move freely between direct competitors without a single legal consequence. Minnesota, North Dakota, and Oklahoma are close behind. Even in states that do allow non-competes, courts routinely refuse to enforce agreements that are too broad, too long, or applied to workers who didn't actually have access to sensitive trade secrets. So where does that leave you? Holding a lawyer's letter, and the agreement might not survive its first day in court. So why does every single person who gets this letter feel like they've already lost? Because that's the product the letter is actually selling. Not a lawsuit. Fear. Here's how this really works. Your old employer's legal team runs a simple math problem. Filing a lawsuit costs money. Going to court costs more. And if their non-compete is unenforceable, which their own lawyers probably already know, they can spend $50,000 chasing you and still lose. Most demand letters never turn into lawsuits. They're sent by the dozens because the cost of sending them is essentially nothing compared to actual litigation. But sending a letter? That costs almost nothing. And if you panic, call your new boss, and quit within a week, they won, without ever setting foot in a courtroom. The company's legal team has a word for people who don't push back on demand letters. They call them easy. This is the real mechanism. They can't always stop you from working somewhere, but they can make it scary enough that you stop yourself. Now, because not every non-compete is unenforceable, some are narrowly written. Some cover genuinely sensitive information, real trade secrets, specific client lists you personally built, proprietary processes that took years to develop. And some states still give employers real enforcement power. So before you do anything, look at your actual agreement, not the scary letter, the original document you signed. Ask yourself 3 things. First, how long does it last? Anything over a year starts getting hard to enforce. Anything over 2 years is a serious uphill battle for your employer. Second, what geography does it cover? A restriction on your city is more likely to stick than one on the entire country. Third, what work does it actually restrict? If it names specific job titles and specific competitors, that's tighter. If it says any work in your entire field anywhere, that's the language courts regularly kill. Here's the part almost nobody talks about. What if your employer wrote a reasonable non-compete, but they also fired you? In many states, the moment your employer terminates you, they forfeit the right to enforce the non-compete. Think of it like a landlord locking you out and then demanding you still pay rent. A judge looks at that and says, "You ended this." You don't get to have it both ways. If your employer laid you off, cut your pay significantly, or fundamentally changed your role without your consent, they may have already voided the agreement before you ever walked out the door. If your agreement checks all 3 boxes and looks solid on its face, that's when you actually need an employment attorney. Not to panic, but to get a real read on your exposure. Most employment lawyers offer a free 30-minute consultation. That conversation costs you nothing. Quitting your new job costs you everything. But here's the twist most people miss. Even if your non-compete is technically valid, your new employer can fight it too. Your new company has lawyers. They have a financial interest in keeping you. In some cases, they'll defend you directly. Because if they lose you, they lose whatever you brought to the table. Larger companies especially push back hard, because allowing a competitor to claw back their new hire sets a precedent they don't want to live with. Before assuming the worst, have a candid conversation with your new employer's HR or legal department. They may already have a plan for exactly this situation. Let's go back to that letter. The thick envelope. The firm name in the corner. The word litigation at the bottom. You now know what that letter actually is. The agreement might be unenforceable. The letter is engineered to make you quit before you find out. Your new employer might have your back. And the actual cost of enforcing this, if it's even enforceable, is something your old boss has to pay too. They're not holding a weapon. They're holding a bluff, dressed up in a letterhead. This is what honest people don't have the law on their side actually looks like. The law written in complicated language, delivered by someone expensive, designed to make you feel like you've already lost. But the law on this one? It's messier than they want you to believe. And messier, in this case, works in your favor. Get the original agreement. Read it carefully. Check the 3 things: duration, geography, scope. If it looks overbroad, get a free consultation before you make a single move. Do not call your new boss in a panic. Do not quit. Do not respond to the letter without talking to someone first. The panic your old employer created? That was always the whole strategy. Here's what I want you to weigh in on. Should non-competes be banned outright, or do companies have a real right to protect what they built? Drop your answer below, because people have very strong opinions on this one, and both sides have a point.